очень прошу сесть тех, кто еще стоит.
I would ask those who are still upstanding to take their seats. Dear colleagues, we're now going to have a presentation by Mr. Tari, after which I will open the floor to questions. Questions related to the presentations that were heard before lunch, but the trick of the situation is that those who are supposed to answer them specifically asked to present before lunch because they had to leave us, so they're no longer there. So that means that I will have to accommodate you together with the colleagues, together with Mr. Sarbash, who was directly involved in this drafting process for the amendments of the Civil Code. Meanwhile, we are moving forward, and I'm now giving the floor to Mr. Terrier, who is going to cover the same subject as was addressed before, the reform of the French legal system. Thank you, Professor. I represent the Supreme Court instance within our judiciary, the French Constitutional Court, and first of all I would like to say that it is a pleasure for me to be able to present at this highly representative forum. I would like to share with you also some of my impressions. I was highly impressed by the level of organization of this forum. I think this is an unprecedented event globally. Therefore, I would like to extend my gratitude to all the organizers and participants. I think that the mere fact that this conference is taking place is sending a powerful signal, a signal that is not always received by our superiors. We affirm here that law is the main driver of social and economic development. Therefore, it is law that should serve as the confidence-building mechanism, a way of increasing security, because without these fundamentals, economic development is impossible. Production and the increase and the creation of wealth will be simply impossible. I think that these highly representative meetings that explore a diverse range of topics become milestones in our building of confidence and attempts to increase legal security. Another consideration: today, unlike 10 years ago, legal systems of countries no longer compete. There is more cooperation than competition. This is evidenced around the world through various strands. I believe that cooperation is an important factor in promoting legal security in various jurisdictions and in promoting trust in the legal structure of each country, both in the eyes of professionals and in the eyes of the public in general. So these are some of the general considerations that I have in mind. In the old days, a judge could simply resort to the national legislation in order to practice law, but this situation has changed. We as practitioners need these days to understand foreign legislation very well. We need to make references to foreign legal systems as far as private law is concerned. For instance, the Paris Tribunal. Paris is a multinational city. Over 50% of cases related to inheritance or establishment of kinship relations regarding inheritance matters require the application of foreign private law provisions. We have to resort to, refer to, and to know foreign provisions in that regard, and this gives us the opportunity to appreciate legislation of other countries. Not a long time ago, the Constitutional Court was called to make a ruling on a property dispute related to the assets owned by a Russian Orthodox Church in Nice. The Russian Federation laid claim on that property, so we had to work on a document that had been adopted in the early 20th century. This was a document which was signed with the Russian government of the time. Very often we have to refer not only to foreign legislation, but also to foreign legal science on various subjects. Not a long time ago, my court was deliberating on a case related to the rights of indigenous peoples on an island owned by France. So we had to go through Australian legislation, Canadian legislation on indigenous peoples, because it was a matter of finding the right balance between the fundamental values of indigenous peoples and law enforcement practice. So we have to make references and draw upon American law from other continents. This is not obligatory, but it enriches our work at the Constitutional Court. It is now part of our day-to-day decision-making and rulings. I believe that fora like these are a very powerful vehicle to disseminate legal knowledge around the world. It is a highly enriching convention of people, and I'm certain that they contribute to the legal security in our country. So, what about civil law reform in France? Let me go straight to the subject of my presentation. Today my colleague presented, and he already mentioned it, when he talked about the methodology of passing ordinances. The process in question is a rather infrequent practice. The draft document was finally adopted after a series of ordinances had been adopted in other fields of law. This represents an increasingly frequent practice. A typical characteristic of a democratic case is the ability to change or amend laws. As you know, the procedure that we have precludes the Parliament from making amendments in many respects, but we are a parliamentary democracy, basically. So there is a question. The government uses ordinances, and this is controversial. It's causing a lot of debate, political debate as well as legal debate in France. Now, what about the substantive part of this project? Please don't think that the Ministry of Justice was building on the provisions that were compiled in the Napoleonic times, that they were guided by those Napoleonic traditions, trying to adapt them to modern-day realities. Yes, indeed, those provisions, those articles adopted in 1804 have not changed since that era. However, since that time, a lot of private law acts have been adopted in France. A lot of new formats have been introduced, such as labor contracts, transportation agreements, and other mechanisms and vehicles in the business sector. All these new types of documents are added to the 1804 Napoleonic Code. The Napoleonic Code spells out principles that apply wherever specific private legislation does not provide otherwise. Therefore, sometimes specific legal acts are used to complement the Napoleonic framework that has been with us for over 2 centuries by now. Please also understand that case law is another important source of law in my country. In jurisdictions, authorities such as the Constitutional Court are part of this law-based system of state. The case law of the Constitutional Court regarding contract law is such that we need to remember that the Constitutional Court was established even before the Napoleonic Code. Throughout its existence, it has made rulings that serve as the doctrinal apparatus complementing the Civil Code. In France, a judge is required to know the case law of the Constitutional Court. A law-based state comprises not only laws but also case law. One of the objectives of the project we're talking about, that is currently being scrutinized by the Ministry of Justice, is to find those elements in our jurisprudence that can and should be preserved, and to differentiate them from those elements that can be left in the past. The Constitutional Court was contacted several times regarding this new text. We were highly satisfied to learn that only very few provisions had to be struck out from the Ministry of Justice case. I can only give you two instances. The theory of unpredictability, which says that if circumstances under which a contract was concluded change or are modified during times, and we're talking about long-term agreements, one party can compel the other to modify the terms of the agreement. The Constitutional Court has always refused this kind of practice. It has always opposed the theory of unpredictability in order to ensure legal justice. The parties concluding an agreement should specify the range of circumstances that will remain in force for the entire duration of the agreement. If something changes, it should not automatically mean the need to modify the contract terms. The draft, as it was prepared by the Ministry of Justice, considers this issue and stipulates the opportunity for the court, for the judge, to modify contract terms in the event they decide that the change in the circumstances has really taken place, and these changes were impossible to foresee at the time of the signing of the contract. This makes us a little bit concerned as judges, because we know of a number of situations such as the world economic crisis and other similar occurrences. We believe that these provisions, if adopted, would result in parties to contracts going to courts, requiring to remove the imbalance in the obligations of the parties that has arisen because of the changes in circumstances. This could result in an increased number of suits being filed with the courts, and we would like to prevent that from happening. Another provision in that draft concerns unilateral offers, unilateral promises of contract awards. It's a legal tool that is very often used in the business world and commercial law. Very often it is used in real estate transactions. I believe that something similar exists in Russia. I'm referring to a contract in which I commit to sell a certain asset to my partner within 3 months. This is the duration of the offer. So during those 3 months, the person who receives the offer may either consent to proceed with the transaction or decline the transaction.
So the fact itself that one of the parties is withdrawing its obligation within the offer's duration does not mean that will not lead to a responsibility which could be used by the judge and make the parties conclude the contract. But the draft law, which was prepared stipulates the exact opposite. It introduces these ideas, and we believe that over the 2 centuries of judicial practice only prove the relevance of such innovations. Another novelty, another innovation which has been much debated in France is a debatable point with regard to the cancellation of the concept which is known as the freedom of contract. The freedom of contract is the prevailing notion in the liberal system of legal system. The parties should be free in determining the conditions of the contract as well as the contract itself, and they need to negotiate in order to reach an agreement to reach their specific goals. At the same time, there is a notion of fairness of contract. This is an attempt to protect the weakest party. We have to agree that not all of the contracts are discussed between entities with the equal power backing them, and often the sides, the parties are not equal. For example, there's a huge supermarket that enters into a contract with a small farmer. Obviously, this is a disproportion of power, and a similar thing happens when a mobile phone operator enters into a contract with a user or a company that supplies gas or water. So it's not about, obviously the company cannot discuss the terms of agreement with every user. Therefore, the principle of the freedom of contract is realistic, and the law needs to introduce certain corrections to guarantee the freedom of contract. Well, the devil is in the details, obviously, as always, and we will see what happens when this law comes into effect. But it is necessary to commensurate the power of different parties, and the judge may be able to change the contract, perhaps even rewrite the contract, changing the conditions under which the contract can be applied, or the contract can be even deemed void. So between these 2 extremes, as I repeat, the intervention of the judge and the adjustment of the contract and the full freedom of contract, this is where our draft legislation is trying to play. The exception is the notion of the justification of the contract. Under the French law, the contract is valid if there is a subject of the contract, if the parties confirmed their powers and the conditions of the contract do not come into contradiction with the legislation. So suppose I'm a businessman and I want to rent some premises, and then it turns out that I cannot use the premises I'm renting, and it turns out that there is no foundation for this contract. I wanted to have a store, to open a store there, but then it turns out that it is impossible. And therefore, this consideration of the contract could be used by the judge to deem the contract null and void. If we withdraw this notion from the law, then everything will be based on the agreement between the parties. I believe that the fact that this notion was withdrawn is not a very good idea. And the universities were trying to discuss this notion. It was an overall trend towards the liberalization and also putting limits on the powers of the judge. And we were talking about balancing off the interests, which should definitely not take away the considerations of the contract. In 1804, in the Napoleonic Code, there were no conditions that could regulate pre-agreement period, but the in the practice, the courts had to find a solution, and today these precedents found a way into the law. There's a summary of rulings that shows that in case there's an abrupt termination of the negotiations, and in that case, a company might need to pay a fine. And this practice now is in the law. As to the privileged rights, for example, when I say that I give the right to the renter, the right to buy this premises in case such a need occurs, this is very widely used as an legal instrument. This will be also seen in the new code. Also, the obligation to mutually inform the parties, which also exist in the amendments to the Russian Civil Code. We have been looking for this for a long time. This will also be will be supported by law. If one of the parties is not providing full information to the other party, which is relevant for the contract, then the contract may be deemed null and void, and the judge has the power to make that decision. Now, as to the abuse of the weak situation of one of the parties and the flaw in the will or defect of the will, such as the abuse of the needs, the abuse of the dominating position, when the strong party makes this second party, which is a weaker party, to sign the contract. Now the legal practice, the legal precedents are confirmed by the law, and the Constitutional Court has always been of the same view, even though there was no unity in the legal community about this particular issue. When I say professional community, I mean the trades chamber, first of all, large companies. They also believed that the judges' intervention with regard to abuses was excessive. We're talking about the clauses in the contract that leads to the imbalance of power under the contract. We have a commission in France on abuses related to the clauses of the contract, and everyone can apply to this committee, and then the committee decides whether the contracts provided grounds for abuse. This list of possible reasons exists, and as soon as any of the conditions is considered to be an abuse condition, it has to be taken out of the contract. And in any case, the judge will be able to make the ruling with regard to a specific clause or a condition, saying that it may give grounds to abuse. We believe that this may lead to an unfair situation if there are a lot of claims from the parties that may believe that in case there is no negotiations, some of the clauses may be deemed related to abuse. We always specify that we want to protect the weaker party, but at the same time we have to avoid instability in law enforcement practice. The judge may intervene in the negotiation process when it comes to pricing. in the contract, in our court rulings, always believe that one of the parties can point out the price. It doesn't have to be negotiated, but the party that specified the price should be able to confirm the price, to justify it using a system of a procedure for pricing. And if the second party believes that the price is too high, it may go to court and the judge will be able to set the price on his own. This is a new function for the judge, and we have some problems here because it's not clear which tools, which instruments the judge may use when defining the price following the request of one of the parties. As to the responsibility proceeding from the contract, there are very few changes.
The draft code in this part simply reiterates the 1804 code as it has been applied in our practice. There was some serious discussion around the question of the liability that very often arises under Anglo-Saxon law, namely the obligation to minimize damage. In other words, the party that has been wronged should have a way to have a remedy. In other words, if a building has been damaged, for instance, the party that has been wronged doesn't have to pay for the repair, whereas under English law, this party has to do its utmost in order to minimize the risk. In the field of responsibility, in the field of liability, very often we are faced with liability without guilt. And because in a normal situation, a party is liable for breaching the terms of a contract. However, increasingly we are faced with liability being regarded in a broader sense beyond the concept of guilt. In other words, the injured party is not required to prove the terms. This is a matter of transferring the responsibility for repairing the damage on the other party. For instance, if a rail freight company makes a contract to transport some freight, this contract is performance-oriented. No matter what happens, the freight operator, the transportation company, is expected to perform its obligation and to take the freight or passengers from A to B within a specified time. In the safest possible way. If the transport operator does not meet these obligations in terms of the time or the destination, it has to compensate for the damage. And that may result in liability without guilt for a person that partly fails to meet its obligations because the freight company or the transportation operator is not really guilty of the circumstances that arose. I think basically we have simply reiterated all the liability provisions. On top of that, additional elements were added concerning new types of damage.
Вам сколько минут надо еще?
Et cette responsabilité, ces nouveaux types de dommages vont devoir obliger le législateur à réfléchir à de nouveaux types de réparations, et en particulier aux dommages d'intérêt punitifs.
So what about the new types of damage that were added? One example of that is punitive damages, where the amount that is claimed, the amount of compensation, is greater than the damage itself. In conclusion, I would like to stress the importance of maintaining a balance between freedom of contract and the justice of contract terms. after the new text is enacted and is in force, this will mean that the judges will be interfering to a great extent into the contract process. I don't see a big disadvantage in that. What's really important is to equip the courts with all the necessary tools so that court rulings are made in a timely manner and so that the parties do not have to wait for years for the court to rule. Thank you very much for this highly concise and detailed resume of the innovations that you're going to introduce into French contract law. I know that unfortunately you will have to leave us shortly, and thank you for your patience and for staying so long with us. It's a pity you're leaving. Let us now move on. I think we can take some short questions regarding the presentation so far, after which we will go back to warranties and representations, and this will involve our German colleague. Regarding presentations before lunch, do we have any questions? Who would like to ask a question? Shall we go into assurances and representations? Is everything absolutely clear on that? Yes, we can go back to the developers now. Well, some other developers, but they were also part of that. Yes, I have a question. Unfortunately, it's addressed to those people who haven't spoken yet, so it's a strange situation. Nevertheless, this is related to the independent guarantee. There was discussion about whether a banking guarantee is represents an abstract transaction. Because the bank guarantee is independent of the principal obligation, but then there is also the problem of the banking guarantee being a function of the security. So how independent was the banking guarantee from that foundation? Now the Civil Code has a provision to the effect that the banking guarantee is independent of those relations as well. So can we say that it is 100% abstract and independent now? I didn't explore bank guarantees in my work. As opposed to Natalia's work, who focused on that, I think the dominant point of view in literature is that banking guarantee is not accessory, as well as the independent guarantee. According to the classical law of obligations, it represents a legal anomaly because security cannot be independent of the main of the principal obligation. It is subordinated to the principal obligation. But this concept has been explored not by, it wasn't started by us. And does that mean that this is a fundamentally erroneous concept? Perhaps it is. Perhaps it is wrong, but the justification is very clear and straightforward. Businesses need it. Businesses need a very quick guarantee enabling them to acquire an asset, to acquire compensation if there's a problem with the debt, and after that they will litigate, settle matters further, but the guarantee is a quick way of getting a compensation. But back in 1998 there was an information letter from the Ministry of Justice number 27 on a case where the beneficiary was fully compensated, but because they had an independent guarantee, they went for the guarantor, and the guarantor proved that the compensation had been paid fully. So this is how this accessory nature of the guarantee emerged in our case law. But I think these new provisions are a relief in a way, and I think the businesses are happy with that. It may be a very primitive explanation, but that's what I have for you. There is a razor blade type of balance between compensation and damages on the one hand and insuring against risks on the other. Can we say that this is legally coinciding with insurance? Perhaps not 100%. It's a form of quasi-insurance, but you may know about this interesting case that you have, and you know how it evolved and what interpretations were offered. Sometimes it was 100% independent, sometimes semi-independent, almost independent, and all the other shades of grey. I would like to comment on this as well. I think Vsevolod asked this question, not because of the accessory nature of the bank guarantee. What he asked was how much independence it has from the contract that was awarded. For instance, Sergei is beneficiary, I am the payer, Vsevolod is the guarantor, and we make a contract with him according to which he should provide a bank guarantee, and then there are problems with the contract. It just doesn't go forward. I think that these innovations in civil code are not helpful here, because the bank guarantee is absolutely independent of that. When people talk about bank guarantees, of course, they talk about it through the lens of the principal obligation. And I think the reason for providing a guarantee by Sergei as a bank will be our contract. Causa? No, I don't think so, because Causa is part of the deal. For instance, if it's a sales contract, Causa is part of the deal regardless who is selling. And perhaps I differ here from Natalia Raskazova, but it seems to me that this is not the case in our legislation. Guarantee would be invalid if I did not provide security to Vsevolod, for instance, and who needs that kind of guarantee then. So I don't think there has been any significant change in that regard. More questions? Okay, it's all nice and clear with warranties and representations and the like. Oh, no, we do have a question. Yes, please, I don't know where the roving mic is.
Well, as far as I understand, the new revision on the recovery of losses has an issue with regard to the independence. The paragraph stipulates that this provision can be applied regardless of whether or not the contract is deemed null and void. So the question is, do you believe that this is an independent condition? The question is, what is it independent of? And do you think this was the right thing to do? Well, I was against this particular innovation, but the codification committee was always skeptical on the indemnity introduction, but the legislators made a different choice. So what is the logic behind this independence? As far as I understand, it is important to cover the risks that are borne by the creditor on the obligation, especially in those cases when the creditor has losses related to the contract. If this contract is null and void for various reasons, then the agreement on the recovery of losses will have to be independent of the fact that the contract was null and void, because the losses related to the fact that it was deemed null and void need to be recovered as well. So I believe in our complicated world, the businesses, especially when there are foreign partners involved, are not sure whether their contracts will be valid, because there are different legal systems. So the businesses say that they are not prepared to bear all the risks, and they will invest only when there is a guarantee that even if the contract is not valid, then the losses will be compensated. I think this was the reason behind it. The compensation will be provided for the losses that were mentioned in the contract, or will all the losses be compensated? What kind of losses are we talking about? I think that the types of losses should be prescribed by the contract, should be mentioned in the contract. You cannot just say, well, all my losses should be compensated for if this contract is not valid, because then you have to prove it. Or else you can specify the losses. I think that's my idea. So, recovery of losses in spite of the invalidness of the contract. Okay. Okay, questions? More questions? Okay, let's move on then. I think we have just received good food for thought, as well as for the next presentation by Lawrence Kader on the sureties in and indemnity in the German law. We will talk about indemnity in more detail here. Thank you very much for giving me the floor, for making it possible for me to speak here. It's a great honor. First of all, I would like to thank the organizing committee and the chairman. I will try to speak in Russian, because then you will only have one language in your ears, which was probably much easier. But if you do not understand something, please let me know. Do not hesitate and tell me to switch over to German, and then we will use the interpreters for that. I hope that, just like my colleague said earlier, the extremist civilists can understand each other without the interpretation. So let me talk about the guarantees in German law. I'd like to talk here about three specific points. First of all, it's representations, and that is, of course, of greatest interest when these are misrepresentations, because if everything's okay, if everything's all right, then no one needs lawyers. The second point is guarantees. We have talked about it at length, and there were a lot of interesting points that were made. We have the same difference between the dependent and independent guarantee, although I believe the notion is defined in a different way a bit. And then the third point is what is called in English as indemnity. The circumstances. Let me start with the first point, misrepresentations. I have to say that under German law, it's important to know when exactly the product is being handed over. And I will be mostly talking about the sales contracts, purchasing and sales contract, sale contract, and other contracts use similar notions, but I would like to take examples from the purchase and sale contract. In this contract, it is important to understand when exactly the product changes the ownership, because then the liability changes. This can be justified by the fact that when the product was transferred, and it will have to be returned, then it will be very difficult to sell it again. So from the economic point of view, you can incur losses. So the German law here makes this difference between the transfer of a product from the conclusion of the contract. If there were any misrepresentations, then they may impact the situation when the product was transferred. And then it will become clear that there were deviations from the agreed upon quality. That is the most popular case, and I will later on discuss more other deviations which are not related to the quality. So the question is, what happens when it's clear that the quality is not there and that the presentations turn out to be misrepresentations? Now, we can say that the seller gets the second chance to perform upon his obligations. We call it delayed performance. The buyer can request the recovery of losses immediately, or the termination of the contract, or the termination of the agreement, because the seller needs to have this second chance. So the buyer cannot terminate the contract immediately. The seller needs to have a second chance to sell the product. There are exceptions. If, for example, the seller used on purpose and misrepresented facts on purpose, then the buyer can request the recovery of losses, because then it's difficult to expect them to believe that the seller will perform on their obligations given the second chance. And it doesn't matter who is to blame. It doesn't matter whether the buyer believed that the facts were misrepresented. And this is important, that the second chance is given. Just imagine a small store selling computers. How can this small store give a new computer and repair the old computer? In some cases, it may be too harsh to apply this law directly. The law was changed about 12 to 13 years ago. And this law originally stipulated that this liability is limited if it happens, if it's not the seller's fault, and that if the expenses for corrections are incommensurate, too large. In this case, the courts and representatives of the academia had a lot of discussions. These discussions are not over yet. Nevertheless, we have a number of principles in place, and I would like to speak specifically about two of such principles. First of all, the buyer can limit his liability if the losses are more than the cost of the product. And the second limit is the kind of losses, what kind of losses were incurred by the misrepresentation? What kind of damages were won? If it turns out that you have to pay more than 200% of the difference between the agreed quality product and the price, the real price, the real quality product, then he can deny responsibility. I think this might give you an overall picture. If the facts are represented in a wrong way, then that's what happens to the quality. In other cases, the misrepresentation may not play as big a role, mostly because the agreed upon quality can be interpreted very broadly. There's no need to have a link to the specific physical condition of the product. I think quality may not be the proper word here, because quality is what is related to all kinds of things. For example, it could be noise. If I'm buying a house and then the street is very noisy, it may actually mean that it is a quality that it is related to housing quality, even though it is not a characteristic of the house itself. There are other types of misrepresentations as well, and in those cases one could request for the recovery of damage or losses, but only those damages that were related directly to the misrepresentation. Not just that the product is wrong, because if the product is wrong, then a different type of regime is applied. The buyer, in this case, can terminate the contract only when its performance is unacceptable. So even if there is such a deviation, you cannot terminate the contract, just like life is complicated, things happen. If all contracts and all agreements where some details did not work well, if all of these contracts were terminated, then we would not have had too many remaining agreements or contracts. The second point I wanted to cover in my presentation, if I still have time left, is related to guarantees. The question is, why do we need guarantees at all if we have a widespread system of legal guarantees for cases whenever the product is not of high quality? And I cannot speak on behalf of everyone here, but let me just say that the notion of guarantees in the German law is different from that in Russian law. It is important to see the context. One word can mean several different things. So it's important not to go down the wrong way. So what are the reasons for having guarantees, even though there is a system of group or collective liability? Now, one of the first cases when the guarantee is required is the independence of the fault, somebody's fault. If the seller or the different party wants to answer the eternal Russian question, who is to blame, then it is possible to think about guarantees.
The second reason is third-party liability, meaning the manufacturer. It is much more beneficial for them because they could become a party in an existing contract, but if there is an independent guarantee that is unrelated to the principal contract, that increases the level of assurances, and that's the second reason why guarantees are required. However, I think the most valid reason for businesses is a different one. This regime that I have talked about is a regime of lawful guarantees, but it doesn't work very well for all businesses. And here, one instance is mergers and acquisitions. If a company purchases a business, another company, and something goes wrong with that company, 5 years after the acquisition, it is practically impossible to return the purchase. A company is not a laptop that you buy, so people want to safeguard themselves, and therefore they agree that this guarantee regime does not apply in this kind of situation. And what's at play here, what is used, is their own system of guarantees, and this is what warranties and representations are all about. In this connection, it is very important that, based on the freedom of contract, this can be negotiated freely by the parties, and in practice this is not impeded in any way, even though Germany doesn't have a specific law on the purchase of enterprises or businesses. There is no straightforward regulation with regard to misrepresentations. The freedom of contract enables the parties to negotiate between themselves about these measures. The fourth reason for guarantees that I would like to highlight is that these lawful guarantees that I referred to earlier usually apply to the moment when a product is transferred to the customer, to the buyer. But a lot of buyers and sellers would like not only to ensure the quality of the product, but they also want that quality to remain at least for some time. And in order to address that, they can also agree on a guarantee that ensures that quality remains for a certain time. Then there is a fifth reason that is relevant. However, I'm putting it in parentheses here because it doesn't play a major role. This warranty applies to circumstances that do not involve any defect in the product. I already said that quality is understood very broadly, so it's very difficult to find something that cannot be remedied using these mechanisms. But yes, sometimes in some situations you can say that this representation does not concern the product itself, it concerns something else, and in that situation it's better to provide a guarantee in order to dispel any doubts. So these are the five main reasons for having guarantees. How much time do I have left? All right. In that case, I'm moving towards the last item, indemnity. Indemnity is a term that does not exist in the German language. However, the principle of freedom of contract implies certain guarantees that can be negotiated with regard to compensation, and there are certain provisions in our legislation, but overall we're talking about a rudimentary regulation here on the level of legislation. And as I said already, it does not pose a problem because of the freedom of contract. One reason why this is not regulated very heavily is because indemnity indemnity is not highly relevant for the customer, for the consumer. In other words, consumers don't grant indemnities, nor are they eligible to indemnities, and the European Union doesn't think it fit to regulate this field. Recently, most of the civil law-related bills, most of such bills within the European Union because the European Union doesn't think it necessary to regulate indemnity, because of that, we don't expect too many bills to appear to that effect. Protection of the vulnerable, the weaker party, that was mentioned already. This doesn't play a role in this regard because it is only relevant for relations between businesses. Nevertheless, the question still remains, why does one need indemnity if there are already rights under law and the negotiation mechanisms that enable special guarantee arrangements? To answer the question whether indemnity is required, whether we need guarantees for the compensation of damage in a certain amount, I can say that yes, this is needed because, once again, guilt doesn't play a role here. Again, this is another problem of quality we're having here. I can't go through my slides. So indemnity does remain a very important guarantee because it is not tied to the question of guilt. And of course one might ask the following question: if you have this regime governing lawful rights, if you have private guarantees, why on top of that should one have indemnity? This is a very difficult question actually, and this brings us to the topic of free lawful arrangements which may contain mechanisms that may not be called indemnity but that operate as such. Nevertheless, indemnity has one advantage, and it doesn't really matter here what you call it. Most importantly, the most important reason is that businesses are in need of certainty of legal implications. If there is such indemnity, one party says this is not going to happen, but then the question still remains: what if it still happens? What if the risk arises? Indemnity is a way of defining what's going to happen very early on and to establish a particular amount that will need to be paid in order to compensate for the damage, or even in situations where there's no actual damage. So this is what I wanted to share with you today. In conclusion to my presentation, I would like to formulate, to respond to the question that Chairman asked in the very beginning of this gathering, when he talked about some of the moral grounds and reasons behind civil law. I think that on a very general level, in terms of our moral fundamentals, the reasons for warranties and representations, I think the answer to the chairman's question is that it all revolves around the freedom of contract, which is indispensable. One question that is valid not only for German law but also for Russian law is what is actually the function or the functions of the code. One approach says that the code is a compendium that regulates everything, so it covers for everything. The German experience over the past 200 years has been that of saying no to this thinking. We realized a long time ago you cannot embed everything in the code. Therefore, the German approach is only to spell out provisions in the civil legislation that are already without a doubt, and those cases and situations that are still doubtful, they're left outside. Sergei Sarbash, one of the most famous Russian civilists, a doctor of science, Professor Sarbash. He is an ex-judge of the Supreme Arbitration Court. Okay, if you didn't hear it, let me repeat it with great pleasure. Sergei Sarbash, most of you know him. He's a professor, he's a doctor of legal sciences. He's an ex-judge of the Supreme Arbitration Court, where he was in the plenary. He's also a professor of the Russian private law school. He was one of its first graduates also. Please, Sergei, over to you. Ladies and gentlemen, thank you. Chair, I have prepared a series of slides, and as you see, the topic of my presentation already contains a lot of unfamiliar words, although I do trust your professionalism to know what I am implying here. We're talking about efforts, the efforts to implement the so-called estoppel provisions in the law of obligations.
Так.
Okay, it only works half of the time, but yes, this is showing me with a card. And in that card you have the estoppel. So let's discuss it. We're in very difficult conditions right now. It's very stuffy here. Not only the people, but the equipment is failing us. So let me explain the origin of this term. I think for a continental jurist, so to speak, this would be more familiar. Venire contra factum proprium. Imagine some time ago, the University of Bologna, we're approaching the year of 1130. Professor Azo has sharpened his quill, Azo, I think, that's the name of the professor. Okay, so what happened back in that era was Professor Azo formulated this principle. Classical Roman law did not explore this rule that is so pithily expressed in these four words. It's a gloss, actually. It's a gloss that was compiled by Professor Azo back then in Bologna, and this is the story. This is how it begins. This principle, venire contra factum proprium, is not a very well-known norm, because this is not how we put it. We usually refer to this principle as the estoppel principle, and this is the term I have used, not because I am so fond of English law, perhaps on the contrary. And it's not because because the Supreme Court, the now defunct Supreme Court, used to term this estoppel. It's just because this is a word that comes easier in Russian. Borrowing from French for Russian seems to be much easier. I'm not even attempting to give you the German equivalent of this term. And the reason I began by talking about estoppel and terminology is because, despite the fact that we're so heavily influenced by English law, we're even borrowing a lot of terms from them. It's because what we are introducing in Russia is not estoppel in the classical English sense of the word. And I think it's important to understand this. It was mentioned already in spring at a round table. It was a much colder time in comparison to now, and Mr. Baibak and Mr. Rybalov were the people who organized that round table. We're thankful to them for bringing us together, for helping us to move forward. So at that round table, the opinion was expressed that what we are going to introduce is not the English estoppel, even though there are a lot of similarities, and those who specialize in English law or structure deals under English law and face the implications of English law afterwards, those people know what this is about and find a lot of similarities with our practice. What is the basic tenet? The basic tenet, the basic principle here is don't contradict yourself. You cannot do it. At that scientific round table, Artem Karapetov compared this principle to pater familias. Pater familias is a serious man, and he cannot set himself in contradiction to his previous conduct. So you cannot contradict yourself. And if you do, and if you're acting in bad faith, the court will not support you. So this is a principle against inconsistent conduct. But what are the main tenets, theoretically, of the estoppel? Shall we call it estoppel, right? I would say estoppel Russian style. Well, of course, this follows from the principle of bad faith, and estoppel is a way of protecting against bad faith behavior. The continental tradition, both in Germany and partly in France, I read about it recently. I remember that being mentioned, estoppel being mentioned by the Constitutional Court of France in a recent ruling, even though there was a publication that said that no, the French should not accept this. They are proud of their own heritage. Perhaps the French colleagues could comment on this. But the idea is very, very simple: protection from wrongdoing, intentional wrongdoing, bad faith behavior.
Well, that does not come into contradiction with my own presentation. The thing is that if the party relied upon certain information, it will try to protect itself. There's one more thing. It is related to the fact that whether or not the protection with the use of estoppel is can be compared to the use of a sword or a shield. And the prevailing opinion is that this is a shield. It is used for protection against contradictory actions, and so the party can use it as a shield. But who receives this shield? Only the person who has clean hands, who acted in good faith. If you didn't act in good faith, you don't have this shield. Like in the computer games, you don't get the shield if you didn't do something you didn't perform. And my final remark is that this is a protection of the expectations. It's like in the contract. Someone does something, I rely upon that and I act in response. So it's in a way like an agreement or like a contract. A certain ideology is similar, legitimate expectations. But a question arises with regard to this category, with regard to this notion. So how does that happen everywhere in the planet? What is the correct way to use this stop-all? There are different approaches. One could try to formulate the universal norm, just like Azar did in Bologna. Remember? It could be a general idea, which later could be filled in with practical applications. So this approach can be seen in the draft common draft of reference. Fairness and acting in good faith specifies the behavior which contradicts fair business behavior, and among other things specified the behavior. I don't know if it describes the behavior. It's very, very complicated and it's very difficult to understand. But there's Article 1.8. It's nothing new. It's not a new discovery. It's not a revolution. These are all very well-known things, and there's a general norm, but there are also specifics. There are some details with regard to the termination of the contract, 3.12, 3.13. There are other unifications that are based on particulars and some specifics. But what is happening in Russia? What is happening with us? And here's what happened. We have a general principle of good faith, but there are several specific estoppels. How many? How many types of estoppel we have? I looked at the literature, and it seems that everybody counts the estoppels the way they want it. The predominating idea is that there are 5 estoppels, and they're all different. So all of them forbid contradictory actions, but in a different way. There are 5 norms, 5 articles. Let's look at what they represent. The first one, and I can't see what's written on the slide. Well, we didn't have a single one, now we have 5. This is a very Russian way. Paragraph 2, Article 166, let's read it. What does that say? It's a very general norm. The party, from the behavior which becomes clear that it wants to retain the deal, cannot deny this deal based on the foundation which was used by the second party. It's very, very general. It's very difficult to visualize even. This is one party, this is the second party. They have a contract, and then it says here, the article stipulates that the behavior showing or demonstrating that the party wants to be in the contract. And so if it is possible, then there will be a shield. The shield, paragraph 2, Article 166. So if you behaved in such a manner that the other party relied on your behavior, then you don't. That's the only way out. This is a very important shield and very important consequence. So what happens next? What happened next is even more interesting. And this is with regard to the void or invalid transactions. Paragraph 5, Article 166. The request about the invalid transactions does not have a legal meaning if the person referring to the invalidity acted not in good faith and if his behavior after the contract was concluded gave reasons to other persons to believe that it is a void, that it is actually a valid transaction. So basically, paragraph 5 is about void or invalid contracts. There are other opinions on this paragraph, but the most accepted view is this, that this is about the void transactions. It might be reduced in terms of the scope. Let me give you an example. Suppose we have void, we have deemed invalid the transaction which was pretended or feigned contract. I believe that there's no way to do something about it. Unless the parties enter into the real contract, they cannot prove that this paragraph of the article could be applied. So I suppose there should be an exception of this rule with the use of a specific language. So there are two parties. You can see two little men here. They have a contract. There's some kind of behavior that give grounds to believe that the transaction or a deal was valid. So once again, the invalidity could be fought against with the use of this shield. There's one more dogmatic problem here, because the court may deem the contract void and invalid on its own initiative. And it's possible that the court may judge that ex officio, and I don't have any responses to that. I don't know how to work it out, but we can think about it all together. There's another estoppel, which is used whenever we have a situation when the contract is contested. So the party that accepted from the counteragent the performance on the contract related to the entrepreneurial activity performed by the parties, at the same time, partially or in full, did not perform on its obligations, cannot request this contract to be deemed void. I think this must be something about the will deficiency. We'll try to visualize this situation for you. So again, we have these two men, two parties of the contract. We have a contract here and a estoppel. Now, this is the this is what is happening in the entrepreneurial activities. This is what is happening, and you have this shield and estoppel. But there is an exception which is related to specific things. First is the rule ultra-virus. Then again deceit and then the second one would be error in essentia. And altogether, there are 4 such exclusions from the functioning of this estoppel. So it seems to be a separate case. And then another estoppel, when it's a new one. This is a situation where the party that accepted from the other party a full or partial performance on the contract cannot request this contract to be deemed void if the claim of this claim comes into disagreement with the principle of fair business. So this is about the loss of contract, but I wanted to show it to you as it differs from the other estoppels. So it's one thing to say that the contract was invalid, and the other one is to say that it is a contract which is declared not concluded. I think a certain degree of unification will be required in the future, because we can see that there are certain similarities in terms of economic conditions, and it would seem that they work to justify these differences. And I'm not going to go into all these differences because I understand that I don't have enough time. It seems that we have reached a certain saturation level, and it looks like the computer thinks that it knows what to show to you. In any case, I can see a problem here. In fact, the small differences between these estoppels could be resolved by interpretation. In some cases, we could limit the application, in some cases expand the application, but I wanted to show to you that these are very well established notions in some legal systems. If we are able to work with the basics, we might be able to work better with them in the future. And finally, according to my estimations, this is the last estoppel we have in the Russian system. This is the estoppel that functions whenever there is a rejection of the contract, denunciation of the contract, and the party that has the right to denounce the contract confirms the contract in other things by accepting the performance of the contract. Then it is impossible to use this as a justification in the second case. So as far as I understand, I have reasons to denunciate the contract, but I make some actions that demonstrate that I'm not going to use this right, that it is not in my interest, etc. And then I cannot change my mind and say, oh, no, I have the reason that I don't want to use now. So this is all. You can't use these reasons because the other party relied on that. It acted in accordance with your behavior. So now the legal system can object to such activities. Let me give you one more example. Article 311, it's a very rare case of the application of this norm. The right of the creditor not to accept the partial performance of the obligation, meaning that the creditor wants to see a full performance on the contract. And in some cases this will not work if it's not possible to divide the performance into smaller parts. Let's suppose the creditor wants to accept and accepts partial performance, and then the price is changed, and the creditor believes that it will be in his interests to withdraw from this partial performance. And then when the second party comes in with another part, then the creditor says, no, I'm not going to do that. So now Article 311 doesn't describe such situations. As to the court precedent, then there were all kinds of decisions made with different circumstances. And as I said to my colleagues, in order to change the contract, you have to perform a number of activities. But it would seem that the necessary requests, the necessary requirements were not met. And they kept saying that this is not about the contract, it's about complying with the types of activities. But now we have a more detailed principle of the fair conduct of business and some even primitive rules of application of estoppel. Starting with June 1st, very soon, Natalia asked us how many days remain. I have a counter. I have a special program that counts down. You have 2 days, 56 and 56, and I don't think that we will get into that. It's not so this is what happens when you want to withdraw from a contract. We mentioned that earlier. What happens when there is a repudiation of the contract? And as soon as I heard that, I remembered that this may be connected with an estoppel. And any denunciation of the contract should be in good faith. But if there's an additional circumstance that gives you sort of the right to violate, then it gives the second party an opportunity to say no to the contract. But this party, in a way, does not always implement its right, even though this right occurs, but somehow it confirms that the contract is not void, that it continues, and this circumstance alone cannot be reason for denouncing the agreement, because there's a estoppel. But what happens if something else occurs? Does that mean that the creditor loses his right forever? No, because if another circumstance occurs, and I really want it to occur, there may be options. So as I said, things work independently here in this computer. Well, in any case, if the second party makes some other violations, then the creditor will have the right to again say no. And the previous estoppel that we forgot about, it has a new rule. And then this is where you can say no. But the main thing is not to go down that alley. I'd like to wrap it up here. Thank you very much. I hope that I'm looking optimistic on this. I'm very optimistic about this particular.
Thank you very much. We can take a couple of questions now, not more. Somebody was raising a hand, no? Is everything clear? Okay. Microphone, please. I've told you everything, didn't I, last night? Yes, but the others haven't heard it. Why is it that Article 433.1 only allows the use of estoppel in cases where a party has not provided a reciprocal security? The reason I'm asking this question is because from the logic that you are describing is based on inconsistency of conduct. And doesn't it work in situations where reciprocal security is provided? Maybe partially, not fully. But don't you think that this consistency principle should be applied in all cases? Yes, Vsevolod, I agree. And this is one of the distinctions of our estoppel, and that's why it begs the question, why is it not always the same? Why is it under a valid agreement it is critically important that the other party that confirmed the validity of the agreement, why it has not provided any delivery. I think this is formulated in this way because it happens so in life. A party concluded a transaction, they have received a certain performance, they have not provided something, they want to get rid of that contract, and it usually manifests itself in that party failing intentionally, or rather intentionally not providing anything in exchange. Or if it has provided something, at least partially, then the estoppel protection disappears. But what you're asking about is a question, and the question should be sought. But I also have reservations about this. More questions? Sergey, I have a more general question. Well, you said that this is an incidence of a more general principle, the prohibition of abuses enshrined in Article 10. What do you think, if we didn't have this degree of specificity in the code, would the courts inevitably arrive at this principle? And can this principle be applied to other cases just on the basis of Article 10? This is a very good question, and it partly fills a gap in my presentation. I forgot to tell you about this. would the courts be able to operate without these principles explicitly stated? Yes, in theory, yes, but in practice they have not, except one case, except one court, but that court is no longer operating. This has always been promoted by the higher instance courts, because the first instance courts, they are guided by the positivist principle. If this is not written in the law explicitly, we're not going to use it. Perhaps this is the way it should be. Trial courts, first instance courts should be guided by ideas that are channeled from above. They don't escalate their case law. Sometimes they do, actually, in some places when there is a lot of creativity on the local level. But yes, there have been a few precedents. They are widely described in a number of publications devoted to estoppel. Actually, there were only a few cases when this was practiced by the lower courts. And you're right when you say you talked about 5 applications. Can't there be more applications in other fields? I think you're right when you ask this question. I think it is possible, and I tried to illustrate this with respect to Article 311. Again, this is a provision about the performance of obligations, the procedure for performing obligations, nothing to do with repudiation of contracts. But yes, estoppel is possible in that case as well. I think what happens is the lawmakers have identified the most common instances when estoppel can be used in real life, and they have described it in the law. It does not mean that estoppel can't be used in other places or applications, even though, I don't know, my colleagues from other countries may correct me if I am wrong. This is not what happens in other jurisdictions. I have given you examples from Unidraft, from draft common frames of reference, but it seems to me that in other places nobody regulates estoppel that explicitly in legislation. It usually comes from case law, from practice of the courts, and people have been saying this to us. Why are you specifying this in the law? It should evolve through practice. But then there were businesses who kept coming to us specifying situations that need to be addressed in the law when they asked about various specific types of deals. But then there were experts who said, no, this should be left to interpretation. This should be down to the courts. But then the businesses said, the courts may be reluctant to apply this if the principle is spelled out very broadly. Please go down to every detail. And this was a concession that was made to the businesses. I'm not happy about it myself, because going too narrow always bears a risk, just as going too broad does. But in a specific court case, the judges will be in a better position to apply this principle. Perhaps there will be other uses that will emanate out of court practice with years. But I think it stands to reason why the lawmakers were that specific. But then, going forward, the practice will probably identify other uses, and both the scholars and the practitioners will come to a common understanding. What's important is that the courts realize the potential of that principle and that they actively apply it in their case law. We have 3 presentations left and very little time. Now we have a colleague from the Institute of Max Planck Institute. This is a researcher who deals with Russia. She's going to talk about her subject, culpa in contrahendo. Thank you very much, Aleksandr Lvovich. I am Evgeny Kurtinsky-Singer. I came from Hamburg. I work for the International Private Law and Comparative Law Institute, named after Max Planck, where I work for a unit that studies Russia and the post-Soviet space countries. I'm now going to talk about culpa in contrahendo as per German law. The first thing to state is that this has evolved in German law through case law. Initially, earlier it was not regulated, it was not specified in German legislation, and it has developed through the practice of courts. Historically, this institution of culpa in contrahendo evolved because it compensated for some of the shortcomings of delict law. You know that German legislation is very old, over 100 years old. In the late 19th century, when the laws were written, a lot of things were overlooked. So delict law was left with two shortcomings that are compensated now by culpa in contrahendo. The first shortcoming was that delict law only applies in situations of damage to assets and interests that are specified in a particular article. Yes, there are exceptions. For instance, there are broad protections offered to commercial enterprises, but the general rule is that delict law does not protect property rights. It only protects material property assets. An example of that would be, for instance, there has been some repair work in your vicinity where you live. An electric cable was cut off, as a result of which your computer was shut down, damaging some of your files. So some of your data is now corrupted. You need to involve a technician to repair that data, and the delict law does nothing to protect your interests here and your damage. A debtor that has defaulted on an obligation is obliged to compensate for the damage unless they prove that they're not responsible for the damage. So there are some restrictions in delict law. The second gap in delict law is that it limits the liability for an implementing party's performance. In other words, if you involve somebody else to perform work for you, you will be responsible within the limits of your liability, and the damages liability, if the damage is incurred by a third party, does not arise for the third part for the principal if, while hiring a contractor, the principal did the due diligence. For instance, a person walks into a shop, slips on the floor and falls because there is some banana peel on the floor that was not removed in a timely manner by the cleaner, and the person fractures their leg. If the shopkeeper can prove that the cleaner is implicated, that there was a division of responsibilities whereby the cleaner was responsible for the safety of the space, that the cleaner acted under instructions, that the shop owner had no reason to believe in the bad faith of that person, then the shop floor is not liable. Under contract liability, it does not apply. One article says that the debtor is responsible for the fault of his legal representative as well as contractor for the same amount as they would if they were acting on their own. The culpa in contrahendo institution expands the possibilities for the injured party to claim damage than under delict law. This is based on the contract relations between the parties, and this gives them, this puts them in a position to impact certain benefits, certain interests, and sometimes the rights of the other party. This ability to impact results in the responsibility to take into account these interests, rights, and so on. This responsibility is in Article 311. This is a novel norm that was only embedded in law after the reform of law of obligations that came into effect in January 2002. Before that, as I said, it had all been relegated to case law. Let us look at the structure of that provision and the related provisions. Paragraph 1 of that section states that in order to establish liability based on a contract, there needs to be an agreement between the parties. The next paragraph spells out the content of the possible contract obligations, and in the second part it says that in accordance with the contract obligations, each of the parties may be obliged to take into account the rights, interests and benefits of the other party. And the next provision says that the responsibility implying the obligations as per the previous provision on diligence arises through the entering into negotiations in order to prepare a contract, the preparation of a contract under which each party, according to the agreement, will enable the other party to impact its rights, interests and benefits, or trusts the other party. Or it may come as a result of business contacts. As you see, this is a very broad definition. Any business relationship may lead, any relationship may not lead to culpa in contra hand. And this is it goes really as far as to embrace situations whereby performance of court rulings may give rise to these situations.
However, the situations where such liability arises doesn't mean that the obligations, the level of obligations would also be as broad, and it will cover all the cases for the third party. There are certain limits of obligations, and the framework for the obligations are determined by the obligation to take into account the interests of the other party. And let's look at this obligation in more detail. In order to determine in which cases these obligations are violated, it is important to understand that the institute of pre-contract obligation is basically proceeds from paragraph 242, in accordance with which the debtor has to perform his obligations in good faith. This is the German Treuenklau Institute. And the limits of acting in good faith are determined by the court on a case-by-case basis. As a result, the pre-contract obligation is something that exists in the German law for a long time. We have a lot of cases, and it's very difficult to formulate common criteria in order to understand how these cases are united, and it's not very easy to do. The range is very wide, from the obligations to provide for the safety and security of the certain premises, and the banana peel example is just one example, and to indicating specific circumstances for the partner under the contract, when the seller needs to tell the buyer that the building was reconstructed, but there was no permission granted for this reconstruction, so it was illegally built. As a general rule, the culpa in contrahendo is an important element here in order to, and both parties need to act in good faith here. This principle of good faith is supported by the reasonable expectations of business operations, and these expectations are varied depending on the situation. When the obligation is determined by the performance of functions, and the circumstances are not mentioned, even though under the contract they should be informed, the party does not have to inform the other party about everything. Even if we have a purchase-sale agreement, when the two parties have very different interests, their obligations do not lead that far. If you know much about antiquity and you see in the flea market something that may, in your view, be valuable and you can buy it for €2, you don't really have an obligation to tell that to the seller, because you're in an equal situation, and the seller could have taken this object to the experts to find out about the market value of this particular antiquity. I apologize, we have very little time left. Okay, so in case one of the parties has an advantage over the other party, then the situation changes. For example, a consumer comes to the bank and wants to buy some kind of an investment. The bank is in an asymmetrical situation as opposed to the consumer, and therefore it's in its obligations to specify the risks involved. And my final remark: at the very beginning I mentioned the methods of how this law can be applied, and this issue of methodology is extremely important. It is important in order to understand how this institute, culpa in extrahendo, can be applied. I understand that I am short of time, so by way of information, if you want to know more about this particular concept, please remember that the way this institute can be applied is yet another interesting area, because it's supposed to reflect the principle of fairness of law, and the judge obviously proceeds from his or her own understanding of what's fair. But this concept of fairness is not coming from the personal experience only. This principle is set in the basic set of values that is immanent to the German law. The German lawyer is brought up within this set of values, because the constitutional law plays a very important role in training of lawyers, and therefore this value system, to a degree, and forms the principle of fairness, and this culpa in extrahendo is just one example. Andrei, you said that you were a very bad moderator. It looks like I'm even worse. I can only give you 15 minutes, and you'll have to tell us everything in those 15 minutes. Well, I don't think 15 minutes is the time we have. Well, people are sitting here, it's very hot, and they don't go away to look at St. Petersburg, this beautiful city. Well, I wrote down some notes. I made some notes on the reform of the law related to security deposits. We have already certain publications. I'd like to concentrate more on questions, if there are any questions. But there are a number of points I wanted to make in relation to the security deposits. It's a number of general points, really. But I wanted to pay your attention to the fact that this is actually a very interesting issue. The thing is that when it comes to the law, the legislators tried to create a more flexible legislation than before, and it's a very good advantage. And in some cases, it is indeed very flexible, but in some cases it is not. And I believe that in some cases additional revision would be required. But on the whole, I believe that the reform was a success. Yet there are a number of negative points, things that have not been taken into consideration, etc. And so I can make a reference to what Natalia said before the lunch break. I totally agree that if don't fix it if it's ain't broken, but there's one thing, for example, without which the whole institute will not work. If it's not regulated, then this entire legislation is in vain. So do we want to keep quiet, or do we want to change that? So what I'm really concerned about is the fact that our legislation is trying to take a different road. It's all about the appropriative right rather than the value of the security deposit. I'm looking at the medieval times. This is something the appropriative right has been abused. An ex-commissary was banned. The fact that we are going back to that in Russia is not good, because I believe that this was introduced into the civil code under the pressure of the banking community. And I think it's a sad innovation. We have made a vicious circle and ended up where the medieval lawyers started with. I don't think this is a good innovation. And I have to say that I'd really want to have legal precedents to go down the way of revealing and determining the actual value of a product. The real sale and a fair sale, not a sale when you sell something to an affiliated company at a lower price. Well, this it costs 1 million, but we expect only 200,000. You can sell it for 200,000 and then you get everything you need, but I will lose 1 million. So where's the guarantee? I think it's only the policy of the court that can change anything here. We have to understand that even the banks are afraid. And I think the banks that will hold an auction would be in their right. If I believe that the product was sold for 200,000, even though it may cost 1 million, then you are in the right. You think that it is 1 million, okay, bring someone who will pay 1 million. If it was purchased for 200,000, then it is 200,000. I think this is the right path down which we should all go. And I urge all the lawyers, especially lawyers working with the banks, to take up auctions. Another thing I wanted to mention here, and this is one of the clearest advantages of the new civil code, is that we can see now rules on the fair principle, including the purchase of the pledge. This is a very important institute which was in the civil code in the past. Now it was revived. It is based on the practice of the higher arbitration court. And finally, the practice of the higher court of arbitration 2011. And this is about innocent buying, or when you buy products without any burdens. And then there's in Russia there's the personal estates and portable property can be used as a pledge. And a special registration was introduced, which is done through the notary public. I believe that this registration is defined too broadly as a registration of all portable effects, but it will only work efficiently when there's an individual code or number. So this is mostly about cars or vehicles with the registration number. How do you use a cow as a pledge? I remember Sergei said, well, they have a register. Yes, but they keep selling these funny records in the register. Pistruka cow from Lipetsk, 1 piece. But as you understand, how can, if you buy this cow, how can you be sure that this is the cow that was there? that was on this catalog. And then people would be afraid of buying cows from that owner because they might be afraid that this is the cow that was pledged. I believe that there's still a lot of work around this, and I don't believe that enough we did not account for the foreign experience. I know that in Germany, for instance, only cars can be used as a pledge here, or other products or other assets that have a registration number. I also liked what happened with the pledge, because I think we have protected the previous holder, and the norms that we have now are quite adequate. But you have to understand that in the economy, which is based on credit, needs to have some kind of a collateral or security. But this is finite. You either have to get the maximum out of the old collaterals, or you have to ask for new ones. If you are my pledge holder and this asset costs 1 million and I owe you 50 rubles, it would be wrong if I wouldn't be able to pledge this product with something else. But our banks hold the position that they are like a dog in the stack of hay. So they hold a position with regard to which they don't take it, and they don't allow to use the product as a pledge in different situations. So it's a complicated norm. I think it's a dangerous norm. This is a response to the interests of banks in forfeits and fines. I mean the situations when, for example, you are the former pledge holder and I owe you 50 rubles plus forfeit, but my pledge is 500,000, and if I could use it as a pledge somewhere else, you will get 50,000 of the main debt. And if there are several pledge holders, you will get the 50,000 first, and you will not get a forfeit. And I think this is a dangerous provision. I was against including this provision, and it's a pity that it found its way into the law. It will be interesting to see what will happen to it. On the other hand, it can somehow inform the banks and try to persuade them that one has to prove the losses and damages and find good ways for compensations other than forfeit. And I can see with my peripheral view that we are very short of time. I think this that there's an innovation with regard to the bank account pledge. We had a roundtable discussion, and the banks said that they were interested, but because of a small detail, it says that you can use your banking account as a pledge, but only if this was a special account that was opened as a pledge. So this is what happens. You have a person who has a very good credit history. He has a lot of debtors. He supplies products, and everybody know his account number. And the bank is interested in this particular account because he can use some amount of money there. But the central bank says, no, the civil code says you have to open up another account. Okay, open up another account, call it a pledge account, but the banks are not interested in that. So there are a lot of little details here. I believe that in order for this norm to work efficiently, we have to make some adjustments. And finally, the pledge with the use of property rights. This institute did not work in Russia for a long time. If you look at the court cases, if you look at the French law or the German law, then you will see that everything's described there. Any supplier will get credited. Well, actually, this is not a very widely used phenomenon, but this is a future property that could be used as a pledge. So they try to use the maximum of every pledge to credit the economy. In this version of the civil code, the pledge of property right is prescribed, but not well. We don't have the institute, which is widely spread in Germany. And if you pledged the property rights, and my debtor owes me 1 million rubles, for example, so what would be the price for this right? Either you will take this right if you are a pledge holder, or it will be sold. So who will buy the property right? If it's an unknown person, how do you know that you will get something? So there will be no buyers. If there are buyers, they will buy it for, say, 100,000 instead of 1 million rubles. And there are two options here. Who will buy? The debtor may not pay at all, and then this 100,000 is not worth it, or he will pay the entire million, but 900,000 would be the profit. 100,000 was invested, 1 million was received. And it would be difficult to get into the fair pricing in this situation, because the usual mechanisms that work with tangible assets do not work with rights. I think we'll have to think of something. As far as I understand, in Germany, this right is transferred to the creditor, but not forever, because otherwise you'll have to do the assessment. But it is only done for the period when you want to recover the debt. So if you raise more than a certain amount of money, say 400,000, from the debtor, then you have to give back the rights. This is very important, and this is something that needs to be discussed in more detail. I believe that the banks that will work actively in this area, that will learn more about it, I think they will have a big advantage in terms of crediting. They will get a very good tool for pledging. Thank you very much.
Mr. Nurbekov, 7 minutes for you, as we agreed, please. Yes, could you please put my presentation on the screen? I represent businesses in this session, and my colleagues from the business circles always ask me this question. Please don't explain what's not permitted, but tell us what can be done. And I think this should be the focus of our sessions. Rather than talking about restrictions and problems, we should talk about the feasible mechanisms. Next slide, please. In the business community, we highly welcome the results of this ongoing reform, because we are an investment fund that works a lot with businesses over the internet. We have covered over 26 regions of Russia with our transactions over the past 6 months only. Therefore, I can assure Natalia that there is a lot of awareness about this new legislation. But as investors who are not participating in the management of businesses, we favor the following innovations mostly. Article 306, even though it may be controversial, is interesting because investment transactions, investment deals can now include the so-called indirect damages that were not possible to address earlier. The reform focused on the type of situation when an investor purchases an interest in the company. Using this mechanism, they can recover not only direct losses, but also losses incurred as a result of various management problems within a company that resulted in tax consequences, or that result from other disadvantages of the company when that company is sold. Today we did not discuss the balance between assurances and representations and losses. For instance, the representation that the accounting practice is in order is a very important one, because if it's a misrepresentation, it should result in the recovery of losses or a forfeit. But most importantly, it is possible to cancel the agreement. And the interesting thing here is that if that misrepresentation is made, it may result in tax claims from the tax authorities that will reduce the value of a company as an entity. But this is not what I wanted to talk about. I wanted to mainly focus on the context in which the reform developed and why this reform is so relevant in today's context. As the businesses see it, the rationale behind the reform was that Russia is trying to establish an international financial center. That was the original rationale, because Russia failed on that, but along the way, additional reasons emerged, such as de-offshoring. The de-offshoring policy against the backdrop of the devaluation of the ruble and the sanctions created a situation in which small and medium-sized businesses, such as my fund, small and medium-sized businesses were very limited in terms of using foreign law. We had been used to, our lawyers had been used to using foreign jurisdictions, but now that we don't have access to them, we should try to establish similar realities under Russian law. The de-offshoring trend that is currently underway has not only fiscal implications, but it also improves the climate in this country in terms of doing business. The problem is that last year we had incoming investments in the amount of 20 billion rubles, and about $150 billion left the country. Currently, the quality of regulation and upgrading the quality is therefore a very important concern for Russia. Finally, I would like to say that the government seems to appreciate the importance of these processes. In May, a list of presidential decisions was published following on a meeting with entrepreneurs that was hosted by my foundation. One of the instructions was to improve the regulation of the relations between the businesses and the government. In conclusion of my short presentation, I would like to say this. Against the backdrop of the current economic situation, and given the need to give some meaning to the offshoring processes that are currently ongoing, the important tools for us include the public loan for open joint stock companies such as ours. Last year, amendments were signed to the law on on legal entities. They have not yet been incorporated into practice, but these amendments are very important for us, for the investors, in terms of governing contracts. We believe that the contract that has just been completed is a positive one. We hope that it will be very successful in the end. Nevertheless, we see that many private investors still have very valid needs that need to be addressed, so this work needs to be continued. Okay. Now, very briefly about this drawn-out process of discussions. Let me try to summarize. I think in addition to addressing some specific situations, we have talked about some important general things as well. The principles behind the evolution of our legislation. There were three things that were very distinctly expressed, in my opinion, apart from some questions that were not addressed. I think there were three things that were stated very clearly. Number one, the law should the law be specific, very detailed, very down to earth, or should it be very broad, very flexible, and very conducive to resolving issues that can never be thought of when the law is drafted? Unfortunately, it seems that the new amendments are sometimes excessively detailed. We have seen some instrumental norms embedded into them, but I think we also were quite successful in providing for sufficient judiciary discretion. I'm not going to elaborate on this. Suffice it to say that Article 393 concerns me significantly in that it empowers the court to assess damage, appraise damage, regardless the actual damage that occurred. Yesterday I heard some praise in the next room with people saying that we're finally adopting truly European legislation. I think the proof of the pudding is in the eating. Once we have case law and court awards in real life, we may reassess these amendments, especially that they are inconsistent and controversial. They begin with one thing and they end with something quite different. The second central theme is the equality of the parties under the law of obligations, the issue of equity and justice. I think Mr. Terrier said something that resonates with us very much. The article on the adhesion contract now has this new small provision that is being overlooked currently. It's somewhere on the fringes, but it resonates with what the Supreme Court in its plenary ruling said when it referred to the freedom of contract. But in the end, it stated that overall the rulings, decisions should be just and fair, and that's what the new amendment talks about. When it says that for contracts that are non-adhesion contracts, the same principles shall apply. And the third central theme concerns foreign law. From what I heard today, I realize that we should certainly try to do the best possible job using our own existing law. And the question is always, should we specify norms or should we rely on case law? I think that the question of warranties and representations could have been much better resolved through Supreme Court rulings and the higher arbitration court rulings, rather than specifying it in the law where it really stands out without any logical connection with other options that are available under the same legislation for sales contracts, for insurance scenarios, and other highly related circumstances. If we are to borrow from foreign legislation, we have to exercise caution regarding the possible implications. And I'm afraid that indemnity is going to present us with a number of unpleasant surprises until case law straightens it out. At this, thank you. I would like to say thank you for your patience. You have to have a lot of patience to endure for so long. Thank you for your interest, thank you for your commitment, and since you are so committed, that gives me reason to believe that we will be making progress. Thank you.